Good morning, everyone. My name is John Lloyd Aitiano, first year B Screen. And now I'm reporting the law enforcement pillar. The law enforcement pillar, for the purpose of this presentation, refers to the police, especially the Philippine National Police or the PNP. Police is a generic term referring to any government agency that enforces laws. Hence, this chapter focuses its topics to matters concerning PNP and its role in the CGS, considering that it is the main law enforcement agency in the country. Other law enforcement agencies, like the National Bureau of Investigation, Philippine Drug Enforcement Agency, Philippine Coast Guard, and others are not included in this chapter. What is law enforcement? Law enforcement is any system by which some members of the society act in an organized manner to enforce the law by discovering, deterring, rehabilitating, or punishing people who violate the rules and norms governing that society. It is most frequently applied to those who are directly engaged in patrols or surveillance to dissuade and discover criminal activity. For example, those who investigate crimes and apprehend offenders, and a task typically carried out by the police or another law enforcement organization. Who a law enforcement officer? A law enforcement officer is someone who enforces a law by discovering, deterring, rehabilitating, or punishing people who violate rules and norms governing that society. It also refers to a person directly engaged in patrolling or surveillance to dissuade and discover criminal activity, as well as investigates crimes and apprehend offenders. Fundamentals of law enforcement. The consistent application of fundamental principles in law enforcement is necessary to avoid human rights violation and maintain respect to the profession of the PNP. PNP members must be guided by the following principles of Robert Pell in 1829. The basic principle for which the police exists is to prevent crime and disorder. The ability of the police to perform their duties is dependent upon public approval of police actions. Police must secure the willing cooperation of the public in voluntary observance of the law to be able to secure and maintain the respect of the public. The degree of cooperation of the public that can be secured diminishes proportionately to the necessity of the use of physical force. Police seek and preserve public favor not by catering to public opinion but by constantly demonstrating absolute impartial service to the law. Police use physical force to the extent necessary to secure observance of the law or to restore order only when the exercise of persuasion, advice, and warning is found to be insufficient. Police at all times should maintain a relationship with the public that gives reality to the historic tradition that the police are the public and the public are the police. The police being only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen in the interest of the community welfare and existence. Police should always direct their actions strictly towards their functions and never appear to usurp the powers of judiciary. The test of police efficiency is the absence of crime and dishonor, not the visible evidence of police action in dealing with it. Lesson 2. The police as the prime mover of the CGS. The criminal justice begins when a crime is reported to the police, or far less often, when the police themselves discover that a crime has been committed. The police is considered as the prime mover of the Philippine criminal justice system. Legal foundations of the Philippine National Police. 1. Article 16, Section 6 of the 1987 Philippine Constitution. It provides that the state shall establish and maintain one police force which shall be national in scope and civilian in character, to be administered and controlled by National Police Commission or the NAPOLCO. The authority or local executives over the police units in their jurisdiction shall be provided by law. 2. Republic Act No. 6975. An act establishing the PNP under a recognized Department of the Interior and Local Government, or the DILG, and for other purposes, also known as the DILG Act of 1990, enacted on December 13, 1990 as amended by RA No. 8551 and RA No. 9708. Number 3. Republic Act No. 8851. An act providing for the reform and reorganization of the PNP and for other purposes, amending certain provision of RA No. 6975, enacted on February 25, 1998 as amended by RA No. 9708. Number 4. Republic Act No. 9708. An act extending for 5 years the reglementary period for complying with the minimum educational qualification to the PNP and adjusting the promotion system thereof, enacted on August 12, 2009, amending for the purpose pertinent provision of RA No. 6975 and RA No. 8551. Two main functions of a police officer. Number 1. To serve and protect. The responsibility of every police officer is to serve the public and protect life and property. No police operation shall be conducted in order to serve or protect the illegal activity of a particular person, group, or criminal syndicate. Number 2. To observe human rights and dignity of person. All PNP personnel shall respect the human rights and dignity of the suspects during police operations. Powers and function of the Philippine National Police. Enforce all laws and ordinances relative to the protection of lives and properties. Maintain peace and order and take all necessary steps to ensure public safety. Investigate and prevent crimes, effect the arrest of criminal offenders, bring offenders to justice, and assist in their prosecution. Exercise the general powers to make arrests, search, and seizure in accordance with the Constitution and pertinent laws. Detain an arrested person for a period not beyond what is prescribed by law, informing the person detained of all his rights under the Constitution. Issues licenses for the possession of firearms and explosives in accordance with law. Supervise and control the training and operation of the security agencies and issue licenses to operate security agencies and to security guards and private detectives for the practice of their professions. And lastly, perform such other duties and exercise all other functions as may be provided by law. Collateral functions of the Philippine National Police. A collateral function of the Philippine National Police is always in collaboration with other law enforcement agencies and police volunteers. They are as follows: to maintain forces and establish police volunteers to sustain the need of the law enforcement, to maintain readiness and mobile forces and police volunteers trained and equipped for employment in emergencies, to provide adequate, timely, and reliable intelligence for us by the PNP and in assistance to other agencies, to organize, train, and equip a force for assignment to an insurgent-affected area, to prepare and submit budgets to NAPOLCOM chairman for the PNP units and offices, justify before the competent authority budget requests as approved by NAPOLCOM, and administer funds for maintaining, equipping, and training the forces of the police regional offices, including the national support units, to conduct research and develop doctrines, procedures, tactics, techniques, develop and procure weapons, equipment, and supplies essential to the fulfillment of the functions assigned, to develop, supply, and maintain police camp spaces and other installation, including lines of communication, to assist other law enforcement agencies when called, requested, or directed, to support the armed forces of the Philippines or the AFP through information gathering and performance of its ordinary police functions on matters involving the supervision of insurgency, and lastly, to support the AFP in combat operations involving the suppression of insurgency and other serious threats to national security. Lesson 3. Arrest, Search, and Seizure. Arrest. These are general guidelines of arrest. All arrests should be made only on the basis of valid warrant of arrest issued by a competent authority, except in instances where the law allows warrantless arrest. No violence or unnecessary force shall be used in making an arrest, and the person to be arrested shall not be subjected to any other restraint than what is necessary under the circumstances. As general rule, arrest can be made on any day of the week and at any time of the day or night. Only judges are authorized to issue a warrant of arrest. A warrant of arrest is no longer needed if the accused is already under detention. An order of commitment is issued by the judge in lieu of the warrant of arrest. Persons immune from arrest. A senator or member of the House of the Representatives, while Congress is in session for an offense punishable by not more than 6 years of imprisonment, and diplomatic agents under the Vienna Convention on Diplomatic Relations, two forms of arrest. The first forms of arrest is arrest with warrant. What is an arrest? Arrest is a taking of a person into custody in order that he may be bound to answer for the commission of an offense. How is arrest made? An arrest is made by an actual restraint of a person to be arrested, or by his submission to the custody of the person making the arrest. What is a warrant of arrest? The warrant of arrest is the written authority of the arresting officer when making an arrest or taking of a person into custody in order that he may be bound to answer to the commission of an offense. Arresting officer when making an arrest. Basis of arrest warrant. Article 3, Section 2 of the 1987 Philippine Constitution provides that the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or arrest shall issue except upon probable cause. To be determined personally by the judge after the examination under oath or affirmation of the complaint and the witnesses that may be produced, and particularly describing the place to be searched and the person or things to be seized. How is warrant of arrest executed? The head of the office to whom the warrant of arrest has been delivered for implementation shall cause the warrant to be implemented within 10 days from receipt. Within 10 days after the expiration of such period, the police officer to whom it was assigned for implementation shall make a report to the judge who issued the warrant, and in case of his failure to implement the same, shall state the reason hereof. Requisites for valid warrant of arrest. It must be issued upon probable cause. The probable cause must be determined personally by the judge himself. The determination of the existence of probable cause must be made after the examination by the judge, the complaint, and the witnesses that may be produced. And lastly, the warrant must particularly describe the place to be searched and the person or things to be seized. What is probable cause in the warrant of arrest? It is defined as the facts or circumstances known by the judge after a careful examination of the complaint. And also, the witnesses that induce the judge to believe without doubt that a crime was committed and a warrant of arrest should be issued. What is citizen's arrest? A citizen's arrest is a warrantless arrest that can be effected by a private individual. It is termed as a citizen's arrest if arrest is made by private individual or citizen. What is alias warrant of arrest? It is a second writ of execution replacing the first one due to expiration. A criminal case may be archived only if after the issuance of the warrant of arrest, the accused remains at large 6 months from the delivery of the warrant to the proper peace officer. And an order achieving the case shall require the peace officer to explain why the accused was not apprehended. The court shall issue an alias warrant if the original warrant of arrest is returned by the peace officer together with the report. 2. Arrest without a warrant. An arrest without warrant is also known as warrantless arrest. The instances of the following warrantless arrest are the following. In his presence, the person to be arrested is actually committing or is attempting to commit an offense. He is also caught in the act or in flagrante delicto. When an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed to it. Or it is called doctrine of hot pursuit. When the person to be arrested is prisoner who has escaped from a penal establishment or place where he is serving his final judgment, or temporarily confined while his case is pending, or has escaped while being transferred from one confinement area to another. Search and seizure. The privacy of the home. The place of adobe, the place where man with his family may dwell in peace and enjoy the companionship of his wife and children unmolested by anyone. Even the king, except in rare cases, has always been regarded by civil nation as one of the most scared personal rights to whom men are entitled. Hence, a man's house is his castle. What is the purpose of the constitutional guarantee against unreasonable searches and seizures? The purpose of unreasonable searches and seizure is to prevent violation or private security of the person and property and unlawful invasion of the security of the home by officers of the law acting under legislative or judicial sanction, and to give remedy against such an usurpation when attempted. Lesson 4. Rights of person arrested or under custodial investigation. Basis of rights person arrested. A. Universal Declaration of Human Rights, or the UDHR. The UDHR is a common standard of achievement of all peoples and all nations to the end that every individual and every organ of society, keeping this declaration constantly in mind, shall be strived by teaching and education to promote respect for these rights and freedoms and by progressive measures, national and international. E. 1989 Philippine Constitution. Article 3, or the Bill of Rights of the 1987 Philippine Constitution provides that the right of every Filipino with some of its provisions are anchored on the UDHR. C. Public Act No. 7438. This act defines certain rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers, and providing penalties for violation thereof. What is custodial investigation? It involves any questioning by law enforcement people after a person is taken into custody or deprived of his freedom in any significant manner. That includes inviting a person to be investigated in connection of a crime of which he is suspected and without prejudice to the inviting officer for any violation of law. What is exclusionary rule principle? The exclusionary rule principle mandates that evidence obtained from an illegal arrest, unreasonable search, or coercive investigation, or in violation of a particular law must be excluded from the trial and will not be admitted as evidence. Evidence excluded by the 1987 Philippine Constitution. Evidence obtained in violation of the right against unreasonable search and seizure. Evidence obtained in violation of the privacy of communication and correspondence. Evidence consisting of extrajudicial confession which are unconcealed. Evidence obtained in violation of the right against self-incrimination. Lesson 5. Police in the filing of criminal action. There are two modes of instituting criminal action. First is the complaint. A complaint is a sworn written statement charging a person with an offense subscribed by the offended party and if his officer or other public officer charged with the enforcement of the law violated. Second is the information. An information is an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed with the court. Elements of a sufficient complaint. One. Name of the accused. The complaint must state the name and surname of the accused or any appellation or nickname by which he has been or is known. If his name cannot be ascertained, he must be described under a fictitious name with a statement that his true name is unknown. 2. Designation of the offense. The complaint shall state the designation of the offense given by the statute over the acts or omissions constituting the offense and specify its qualifying and aggravating circumstances. If there is no designation of the offense, reference shall be made to the section or subsection of the statute punishing it. 3. Cause of the accusation. The acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language and not necessarily in the language used in the statute but in terms sufficient to enable a person of common understanding to know what offense is being charged. 4. Place of commission of the offense. The complaint is sufficient if it can be understood from its allegation that the offense was committed or some of the essential ingredients occurred at some place within the jurisdiction of the court, unless the particular place where it was committed constitutes an essential element of the offense or is necessary for its identification. 5. Date of commission of the offense. It is not necessary to state in the complaint the precise date when the offense was committed except when it is a material ingredient of the offense. The offense may be alleged to have been committed on a date as near as possible to the actual date of its commission. 6. Name of the offended party. The complaint must state the name and surname of the person against whom or against whose property the offense was committed or any appellation or nickname by which such person has been or is known. If there is no better way of identifying him, he must be described under a fictitious name.